The views expressed today during this webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered an authoritative panel of energy attorneys to examine the current trends in state laws, leveraging pooling in contract negotiations and dealing with conflicting rights of landowners. The panel will provide the perspective of both the operator and the landowner. The panel will also provide a point-counterpoint between states with forced pooling and those who do not. Our panel today includes Dick Emmons, partner at Emmons & Wolper in Columbus, Ohio, and he is joined by Jack R. Llewellyn, senior counsel at Hutch Blackwell in Denver. When you're ready, we'll get started.
Okay, this is Jack, and I'm starting this off. Let me give you a kind of the outline and an introduction and a few disclaimers before we get started. So, as the moderator said, we're going to talk about forced pooling in a couple of different ways. First, we're going to start off with some definitions and some basic concepts of the ideas behind pooling and forced pooling and why forced pooling exists in the first place. Then we're going to look at some state laws regarding forced pooling, and what we're going to do basically is walk through two different statutory regimes, one from Colorado and one from Ohio, that'll give you a good indication of how states deal with forced pooling and why there's some differences and distinctions between the two. Dick, in particular, then is going to talk about some conflicts between landowners, particularly the distinctions between situations where the landowners own the minerals and the surface, or when they own only the surface, or when they own only the minerals. Then we'll talk about some landowner versus operator distinctions, and then last, if we have time, we'll talk about some conflicts over mineral rights and forced pooling. But for our introduction, I want to talk about a few definitions and a couple of definitions and a couple of disclaimers that aren't on the screen yet. One of the things you're going to get today is a nice distinction between landowner and operator in East and West. I practice in Denver. Dick practices in Ohio. Dick primarily does work with landowners. I primarily work with operators. And so one of the things we're going to try to do is have a little bit of a dialogue, a little bit of a back and forth, particularly later in the presentation, so you get a good understanding of pooling and forced pooling, both from the perspective of the landowner and the operator. And you'll also notice, especially when we go through this state statutory regimes, some real differences and distinctions between laws and concepts in the West and laws and concepts in the East. And then one disclaimer before we really get going. This is, by its nature, is a little bit of the 10,000-foot view on things. We're going to make some generalizations, so forgive us if you know that there's some exceptions to the rules that we're talking about, or some cases that are slightly different than what we might be talking about. Again, what we're trying to do is give a pretty good overview of this subject from the two different points of view that I talked about. So with all of that, let's get some basic definitions out. And before we really talk about pooling, there's a couple of other definitions that I think are very important for us to agree upon and to understand, that are very closely aligned to the issues of pooling. So one of those is the concept of spacing. And spacing, generally speaking, is the distance from property lines and other wells that dictate where certain wells can be drilled. So wells are generally required to be drilled a certain amount of distance away from property lines and away from other wells. Density, on the other hand, is a concept of how many wells can be drilled in a particular acre or a particular set of acres. And then there's an idea of a drilling unit or a spacing unit, which is a designated area for drilling, generally in order to get to a common source of oil or natural gas. And so thinking about those lead right into a lot of the concepts that we're going to talk about with respect to pooling. And so now let's go to the definition of pooling. A kind of a broad general definition of pooling is as we have here on the slide. And it is the joining together or combination of separately owned tracts or portions of tracts to create sufficient acreage to receive a drilling permit under applicable state spacing rules and regulations so that production costs are shared by all working interest owners and production is shared by all of the mineral interest owners in the pooled unit. To put that into maybe a little bit more of a layman's terms, what it really is if I own a tract and Dick owns a tract of land, and we're the working interest owners, and it is better for geologic reasons, and we'll talk about this concept in a moment, but it's better to drill those two tracts together rather than separately. We join those together, and then they are really treated as a combined tract or one tract, so that Dick and I would share the costs of production, drilling and production, and we would also then share the production and any proceeds from the production from that pooled acreage. So forced pooling is the idea of being forced to participate in an oil or gas production unit. So this combination, and we'll talk about this in far more detail, but that combination of separately owned tracts can be forced upon mineral owners by state law. There's also a concept of unitization, which is, for our purposes at the moment, the combining of multiple wells to produce from a specified reservoir. And unitization is a little bit interesting because in the West, we tend to think of unitization more, A, with respect to federal lands, and B, with respect to secondary recovery. And historically, there really was a difference between the two. Pooling was just the combining of small tracts for primary recovery. Unitization was mainly for secondary recovery. Over time, in many states, including, and Dick will talk about this a little bit later, including in Ohio, those differences have really disappeared in statutes and in common usage. So most people now, if you're talking about the idea of forced pooling or statutory pooling, it's going to refer to both primary and secondary recovery. As I mentioned a moment ago, sometimes pooling is done voluntarily. So again, to use the Dick and I example, sometimes there's benefits to Dick and I saying, hey, it's better to join forces, be together, and share in expenses and share in production. And so voluntary pooling happens frequently. Most oil and gas leases have a provision that allows the lessee to pool the acreage that is covered by the lease. And a standard Producers 88 paid-up oil and gas lease has a pooling provision. Now, you'll notice I put in quotes the word standard and the word typical because I think in modern usage, there's nothing is standard and nothing is typical, and everything can be changed. But again, in a producer's 88, there is a typical or a common pooling provision, which is on the screen here, and I'm just going to read it because I think it's important. Lessee, at its option, is hereby given the right and power at any time and from time to time as a recurring right, either before or after production, as to all or any part of the land described herein, any part of the land being leased, and as to any one or more formations hereunder, to pool or unitize the leasehold estate and the mineral estate covered by the lease with other land, lease, or leases in the immediate vicinity for the production of oil and gas, or separately for the production of either, when, in the lessee's judgment, it is necessary or advisable to do so, and irrespective of whether authority similar to this exists with respect to such other land, lease, or leases.
Jack, can you go back to the previous slide for just a minute, would you? The last 6 words there, I wanted to comment because it starts showing the difference between the approach that the companies take and the landowners want. Typically, companies are going to want very broad authority in terms of how many acres, or as you say here on this slide, virtually unlimited as to the acres. But the landowner is going to want that limited so that he or she has a larger percentage of the production from the unit. Okay, let's go to the next slide again. And on that, I wanted to comment on this. This talks about at any time and from time to time. In the first slide that we had, and I'm not going to ask you to go back to that, but it talked about the timing of the drilling, and it talked about getting a permit for forced pooling, which would be the, if you see there, thank you for going back.
I got skills.
To receive, there you go, to receive a drilling permit. Now, the later slide, the one that we're just on, that has the standard producers 88, go back to that. That one talks about the right and power at any time and from time to time. And I note that some of what, my screen just went blank. I don't know what is happening. There, okay. But in Ohio, which we'll talk in more detail about later, in both cases, with the small tract and with the larger tract unitization, it's only with the permit to drill, and not doing forced pooling after production has been obtained. That's the way it's currently being interpreted. I'm assuming that the forced pooling after the wells have been drilled would really refer to secondary recovery. But I'm asking if that's the way you look at it in the West.
Not necessarily. So you can force pool after it's been after a well has been drilled, though that's not typical.
How do you then, in the landowners don't even get notice? There's a well drilled and people who don't get notice?
Well, can I suggest that we pick that up when we get to the landowner versus operator later on?
Absolutely.
Otherwise, we may not get back on track. So let me hop back into the idea of forced pooling. So sometimes under the lease, whether it's the producer's 88 lease or a non-form lease, and whether there are some limitations to it, but oftentimes, again, people think it's to their advantage to be voluntary pooled. But sometimes you can't do that. How could that come up? Well, first of all, you could have a situation where somebody just says, no, I don't want to be pooled. I don't want my, I landowner have, or mineral interest owner have a big piece of my pie, and I don't want to share it with other people. I don't all of a sudden want to have my acreage be combined with lots of other acreage and end up in a situation where I'm getting less. Sometimes you're in a situation where you can't find lessees, in which case you can't get them to voluntarily agree to be pooled. So in those sort of situations, in many states, and certainly not all, and we will talk about that, but many states provide for statutory or compulsory pooling, or what I think is more generally regarded as, or referred to as, forced pooling. And under forced pooling, various tracts can be joined even without the consent of the mineral interest owners, and in fact frequently over the objection of the mineral interest owners. And so you may be saying, well, how in the world does that make any sense? How is it that a mineral interest owner can be pooled with others even without their consent? So here are some policy thoughts and some ideas as to why that has, the idea of forced pooling has been developed. So one is, people would say that a mineral interest owner who refuses to enter into a lease shouldn't be permitted to forestall development and production of oil and gas resources. So if you have a situation where, from a geologic perspective, it's important to be able to pool certain tracts in order to more efficiently drill that acreage, somebody who doesn't want to be pooled shouldn't be able to effectively block the efficient, or maybe block completely the production of oil and gas. And oil and gas law has lots of examples where there is the idea, the concept that there is a societal good for the extraction and development of oil and gas resources.
And Jack, I think the term conservation here, it's important. That a lot of people think of conservation as preserving or saving, but from the state standpoint, conservation is considered to be the efficient production, the words that you were using, and I think that's a major basis for this. But what it really amounts to, something very similar to eminent domain, and I can tell you and our audience that trying to explain, especially to a recent landowner who owned both the surface and the minerals and had more than 200 acres and was being told, if you don't lease, we're going to force pool you, it's very difficult to explain the reasoning behind that.
Absolutely. And I've got a quote that you haven't seen, Dick, that I'm going to read in a moment here that I think encapsulates exactly what you're saying. Again, the idea that forced pooling promotes the more efficient extraction of natural resources, and then there also is the concept closely aligned with the previous two, and closely aligned with what Dick was saying, that forced pooling is really necessary because it is unfair for fractional owners of mineral interest not to generate royalties through the production of oil and gas because a minority mineral interest owner would not sign a lease or couldn't be found. So, in other words, if I own a mineral interest and the only way to really develop the acreage is through a pooling situation, and if there's somebody who doesn't want to sign a lease or can't be found, it's unfair for me not to be able to generate royalties, generate oil and gas based on that. I found a quote today from Professor Kramer, who I think most people in the oil and gas industry or know, a prolific writer, and he has a very short 2 sentences here that I think does a really nice job of kind of encapsulating the ideas of why some people think forced pooling is important from both a societal and an economic point of view. So, and again, it's only 2 sentences, so forgive me for reading it, but Professor Kramer says, the function of the compulsory pooling process should be to remedy the weaknesses of the marketplace while achieving the public objectives of preventing waste, conserving oil and gas, and protecting correlative rights. Because of the impact of the rule of capture and the geologic quality of the movement of oil and gas to areas of lower pressure, the marketplace may not operate as the ideal mechanism for the allocation of this scarce resource.
Yeah, I think that's really good, Jack, and I think we all recognize, or at least we do, that Professor Kramer is, in our opinion, the leading authority on this subject in this country.
And again, I apologize for not having that on a slide, so if anybody, for whatever reason, wants to know where that came from, I'm more than happy to present it. So with that, I think that gives us a decent concept of where, of the idea of forced pooling and some definitions. So now we want to talk about state laws regarding forced pooling. And it's easy to do a list of states that clearly have forced pooling and some that don't. A lot of the oil and gas producing states, and you can see the list here, and we took it from Williams and Myers as the footnote shows. So below are here are many of the jurisdictions that have a form of a forced pooling statute, including Colorado and Ohio, as we'll talk about. I think you can quibble on a couple as to exactly how they operate, whether it's just a forced pooling statute or a unitization statute or a combination of both, but nevertheless. And then there are a few states that don't have forced pooling statutes. Texas, in particular, is an oil and gas jurisdiction without any type of a forced pooling statute. So now what I want to do is, or what we want to do, is to walk through both the Colorado and the Ohio statutes, because when you see how the forced pooling statutes work, and the mechanisms behind them and the steps that have to be undertaken in order to have an order of forced pooling, I think it gives a really good overview and a good idea of the concepts of forced pooling, and then we'll be able to apply those as we talk later on about the interaction between landowners and operators. So in Colorado, forced pooling, not forced polling as it says here, is authorized by statute 3460, 116, and the statutes around it. And that statute says, when two or more separately owned tracts are embraced within a drilling unit, or when there are separately owned interests and all are part of a drilling unit, then persons owning such interests may pool their interests for the development and operation of the drilling unit. So what it says is, hey, just as we talked about, you can voluntarily pool your interests, and you have the statutory right to do that. Then it says, though, hey, in the absence of voluntary pooling, the commission, which in Colorado is the Colorado Oil and Gas Conservation Commission, upon the application of any interested person, which almost always is the operator looking to drill, but the commission may enter an order pooling all interest in the drilling unit for the development and operation thereof. Importantly, each such pooling order shall be made after notice and hearing. So in Colorado, there is always going to be a hearing of some kind with respect to the establishment of a forced pooling order. And that hearing will require a couple of different things. Not only a demonstration that the mineral interest owners have received notice, or that there's been an effort to give notice to the owners, but also that there is a geologic necessity. And so you will generally have both an engineer and a geologist testify or provide affidavits saying, we need to pool this acreage because in the absence of the pooled acreage, going back to Professor Kramer's quote, we will not be able to drain the resource efficiently, and therefore we will not prevent waste, we will not conserve oil and gas, and we will not be protecting correlative rights. And those three concepts are central to the mission of the Oil and Gas Commission in Colorado, and I think in most every other state where there's a similar commission. Let me skip that slide because I already talked about it. Okay, so I'm going to walk through Rule 530, which is the rule for the Colorado Oil and Gas Conservation Commission that deals with involuntary pooling proceedings. And I'll move fairly quickly through this, but again, I think that walking through it and taking some time to understand it is important because it really shows in practical detail how forced pooling is dealt with in the West. This process is not dissimilar to the process in most, at least of the Rocky Mountain states that have forced pooling statutes. So again, as the statute had said on 2 slides ago, the rule also provides that involuntary pooling may be initiated pursuant to an application by any interested party, which is often is, or generally is, a party owning an interest in the mineral estate of the tracts to be pooled. Often that is the operator. Again, a forced pooling application can be filed at any time prior to or after the drilling of a well, and I'll touch upon that in a second, but any involuntary pooling order issued is retroactive to the date the application is filed. So let's walk through that because it's important and it goes back to a question Dick asked. So a forced pooling application can be filed at any time, but if it's issued, it's retroactive to the date. And actually, I think I have this wrong. So let me back up because I think the slide's incorrect. It goes back to the date of the drilling of the well. So why would you not want to force pool before you drill a well? Well, what happens if it's an uneconomic well? You've gone to, in lots of cases, a fair amount of expense and trouble to get to get a pooling order. Again, you have to notice all of the mineral interest owners. Oftentimes that requires a title opinion. It requires sometimes Herculean efforts to try to locate people. One of the things that's happened in Colorado over time is there's a lot greater burden to show that, yes, we have been trying to find everybody, and here's what we've done. And again, you go through all that expense. You get your geologist to analyze things and present it to the Oil and Gas Commission. You have your engineers provide expert testimony, and then you end up with a non-economic well. So a lot of times what will happen is you'll drill the well, say, hey, this is going to be good. We now have a resource that we know is going to be productive. Now let's go and force pool, and we'll just make the force pooling retroactive to the date of the drilling of the well. So an application is filed and notice is provided to the mineral interest owners. Under Rule 530C, an unleased owner shall be deemed a non-consenting owner if, after 35 days written notice, the unleased owner has failed or refused a reasonable offer to lease. So you provide notice and give them an offer to lease, and if they refuse to, or for whatever reason don't execute a lease upon a reasonable offer, then they're deemed a non-consenting owner. In considering whether or not a reasonable offer to lease has been tendered, the Commission looks at a couple of different things. So they'll look at the date of the lease, the primary term, the annual rent per acre, the bonus payment, the mineral interest royalty, and such other lease terms as may be relevant. In practical terms, what this means is, has the applicant, again, most often the operator, has the operator gone to a mineral interest owner with a market-based, legitimate offer to lease? Okay? You can't walk in with something that's not market. You can't walk in with something that's not comparable in that particular area and say, hey, if you don't sign this, you're going to end up being force pooled. All right? So, upon application, a hearing is going to be held, and frequently you end up with a situation where there are experts testifying on both sides. Somebody wants to be force pooled, somebody doesn't want to be force pooled. If a mineral owner, after notice, does not elect to participate in the cost of the well, or does not agree to a reasonable offer to lease, the mineral owner is deemed to be a non-consenting owner. So that, stated differently, if they don't voluntarily pool or agree to a reasonable offer to lease, they're deemed to be a non-consenting owner. In states such as Colorado, there are significant economic consequences associated with being deemed a non-consenting mineral interest owner. The most onerous one, at least from the landowner's perspective, is what we call a risk penalty. And in Colorado, what that means is the statute allows the non-consenting owners of a drilling unit to recover a risk penalty from the non-consenting owner's share of production. And as I note here, the logic behind it is to say, hey, if we're the ones taking all the risk on drilling the well because you haven't elected to participate in the cost of the well, then not only should we get our money back, but we ought to get a little bit more on top for having taken the risk. Or conversely, you landowners shouldn't just be able to ride along on our coattails, hope that everything works out well and we have a great well or wells. You get all the benefit and have taken absolutely no risk. So in Colorado, the risk penalty is pretty severe. And what it says is that 100% of the non-consenting owner's share of the cost of surface equipment beyond the wellhead connections, plus 100% of the non-consenting owner's share of the costs of operating the well, commencing with first production and continuing until the consenting owners have recovered such costs, and 200% of that portion of the costs and expenses of staking, well preparation, obtaining rights-of-way, rigging up, drilling, reworking, deepening, etc., and 200% of that portion of the cost of equipment in the well, including wellhead connections. In other words, the operator, the party that was able to get the force pooling, is going to recover all of its costs plus a 200% penalty on, those items that are listed here before the non-consenting owner gets anything from the production of the well. Again, the idea of being able to provide incentive for operators to go ahead and take on all of the risk and not have to share in all of the rewards right up front. In addition, under the Colorado statute, a non-consenting unleased owner is treated as a royalty owner for a 1/8 royalty, by statute, a 1/8 royalty, until costs are recovered for the well, but is not liable for the risk penalties above. So, again, you've got the two different provisions and two different ways of looking at it. Once the consenting owners have recovered their costs, including the risk penalties, the non-consenting unleased owner then owns a proportionate 8/8 share, his proportionate, so whatever their share would have been in the well, the surface facilities, and production, and then shall be liable for further costs as if he had agreed to the drilling of the well. So going forward, once those costs have been recovered, it's as if the non-consenting owners had participated in the well from the beginning, and going forward, they'll be liable for their particular shares of costs. As I note here, and as I mentioned earlier, the risk penalty or some form of this risk penalty is fairly common, and a number of the states, particularly those in the West, use such a penalty. And you'll note, Texas is in here. There is a risk penalty in Texas, but it's different, and it's different than a forced pooling. So I kind of wish I hadn't put it in there. Dick, unless you jump in and disagree, for purposes of this, ignore that Texas is in there.
And we'll ignore the second New York, because theirs isn't twice as bad.
Okay. All right. Dick, you can talk about Ohio now.
I'll be glad to do that. And it's interesting, as a preliminary comment, I want to say that when we go through Ohio's situation, I think people will notice that it's not all that different from what you described, Jack, although in Ohio there are two specific statutory sections. The one we call 2.7, 1509-2.7, and that is primarily for smaller tracts. And then 59.28 was originally, and I'll describe what I mean by that, put in here as a way to handle secondary recovery. But since the statute didn't use the word secondary recovery, it is now being widely used in connection with the shale play. Let me give our audience a little background on Ohio, because it'll help to understand, and I'll try and do this briefly. But Ohio has had oil and gas production since 1855, and in 1895, Ohio produced more oil and gas than any other state in the country. But between 1895 and the early 60s, while there was drilling and production activity, it was mostly shallow from wells that were not largely productive. It was a very low-cost, low-overhead operation for a number of smaller independent operators. In 1963, there was a major boom in Ohio, up north of Columbus, about 60 miles, and oil and gas operators from all around the country came in to Ohio and liked the fact that there was no conservation statute. There was no spacing, no proration, and the Ohio legislature was roundly criticized, and so acted rather quickly. And I was involved on behalf of the Ohio Oil and Gas Association, who had quite a bit of stroke at that time. They'd been supporting the legislature. So Chapter 1509, which is Ohio's Oil and Gas Conservation Statute that was adopted in 1965, provides for no proration. The state cannot prorate production from any well. And it also provides for a technical advisory council which advised the chief of the Division of Resource Management in the Ohio Department of Natural Resources. And that technical advisory council is comprised of 8 members, 3 that are from independent operators who operate only in Ohio, 3 from larger oil and gas operators that operate in Ohio and in other states, 1 public member, and 1 landowner representative. So that sort of gives you the flavor of what has happened in Ohio. So with 2.7, if the tracts are of insufficient size or shape, then the owner, the operator, can apply for a mandatory pooling order as a part of getting the permit. I'll talk a little bit about what has happened under that section. Under 2.8, this is designed, as I said, for secondary recovery, but it's being used for primary recovery. As long as the operator cannot come to voluntary terms for unitization of the pool, and if it has at least 65% of the land overlying the pool or part of the pool, then the operator can apply for an order for unit operations. The shale activity started in Ohio in 2008, 2009, got going quite strong in 2010, 11, and 12. By the end of 2012, there were roughly 3 million acres leased, mostly in 8 counties over on the eastern side of the state, right along the Ohio River. And initially there were guidelines that came out of the division that spelled out how to implement 2.8, but those have now been updated recently with additional requirements. And it's very complete information, I think not dissimilar from what you described, Jack. The identification of the amount of acreage, how it was determined, the value of recovery in real detail with the net present value discounted for each well proposed in the unit area. Typically, the units are being proposed, started off in the 300 and 400 acre range. Then they moved to 640, and with the extension now, some of the wells have now been drilled horizontally more than 3 miles. So the newer units are of 1,280 acres. And so the estimates of the cost to drill and operate are important and a part of what has to be explained. It's interesting that not only does there need to be an affidavit attesting to the valid joint venture or other agreements that discloses who is participating, but there also needs to be an affidavit where the operator says that they own the leases or their joint venture partners own the leases. That's been a point of contention in some earlier hearings, but I think that's now being covered better. Then there needs to be pre-filed testimony of a geologist and an engineer and a landman. which contains, as we say here in the slide, the name of each mineral owner, current address, and notice needs to be given to all of these people, so that it is a rather detailed, and it's expensive, I guess not to the larger oil companies, but with the filing of the application, you need to pay $10,000 if you're going to apply for a forced pooling order. The additional requirements are listed here. I won't go through talking about how they changed the publication requirements and that sort of thing, but it's now very detailed. There have been 17 unitization hearings that have been applied for since the beginning of 2017, and 6 orders published. Typically, before the new guidelines came into effect, it would take about 3 months from the time, 3 to 4 months, sometimes more, from the time the application was filed until the hearing, and then another 3 to 4 months before the chief issued an order. Under the new guidelines, we expect that that time frame will be shortened considerably. Now, each of the orders in 2017 provide for what is called here cost recovery of 200% on the first well. This is the risk penalty, Jack, that you talked about, and 150% for additional wells on the same unit. Typically, on a 640-acre unit, there'll be 3 or 4 wells that will be permitted, and on the longer ones, they may even have, with more acreage, they may have more. Now, every order that's come out this year has had the 200%, the 150%, and a 12.5% royalty for the unleased mineral owners with no bonus. And that's pretty well accepted as the standard. We've participated, our firm has participated in a number of these hearings over the last several years, and the division is not very interested in varying from what they call the standard that I just described. Now, after the order of the chief is published, then that order can be appealed. But the party that appeals, of course, has the burden of proof beyond the preponderance of the evidence that the unit order was unlawful or unreasonable. The test is just and reasonable, but you can see that, I think I'll read that, the party that appealed has the burden of proof beyond the preponderance of the evidence that the unit order was unlawful or unreasonable. Now, in the all the years that well, I say all the years, obviously it's not many, but nearly 10 now, that there have been these forced pooling. We're talking now about under 2.8, the shale forced unitization, really. There have been only 2 appeals, and in the first one, the operator managed to change the description of the unit to omit the appealing party. In the other one, which our firm handled and had some very unusual facts, basically one company had recorded a memorandum of lease in the county records, even though they did not have a signed lease. And so when the landowner wanted to lease to another company, of course the other company said, well, here's this memorandum of lease. So on that appeal, we were successful in getting the landowner a 20% royalty, but we were still unable to get them any bonus, even though the bonuses at that time were in the $5,000, $6,000, $7,000 an acre. Now, if you look at what's happened with 2.8, there have only been these two appeals over the last 10 years, and the major reason is that it's so expensive, especially for a small mineral owner or an owner of a small tract of land. So it's readily apparent why landowners can't or don't appeal these orders. You can then, of course, appeal it from the Oil and Gas Commission. The Oil and Gas Commission, originally called the Oil and Gas Board of Review, is a 5-member group. One oil and gas attorney, one independent oil and gas operator, major company operator, somebody knowledgeable about petroleum engineering or geology, and one public member. And so...
Hey, Dick?
Yeah.
Is one of the other, in addition to the cost, is one of the other reasons why there aren't a lot of appeals, and I think this is part of why there's very few in Colorado. And in Colorado, there's not that intermediate one, so you'd appeal from the commission to the district court. But even though all the commission members aren't necessarily oil and gas experts, they've developed some expertise, but they've got staff that are, the burden of being able to go in or of getting a court to kind of substitute its analysis of the geology and things for that of the commission and the commission staff seems to be a very daunting prospect at best.
Right. No, I think you're right, and the reason that the legislature created the Oil and Gas Commission was because they knew that most of the courts would not know much about oil and gas. But the major reason that there haven't been appeals is because of the cost. I mean, we've had many landowners who've told us, I just can't afford to do that. And the Oil and Gas Commission does do its own de novo review. But this, again, is interpreting whether the chief's order was just and reasonable. The next slide, we just mentioned that Oklahoma and Arkansas, that a non-consenting, non-operating working interest owner shall have the option to assign or surrender its interest to the operator with compensation or forfeits its share of production. Again, I think the similarities there are much more than the differences. And let me mention the small tract, going back to that, which I'll do very quickly. But the 1509-27 with small tracts, initially we thought that would provide a way, again, for unleased mineral owner or a landowner with a small tract that didn't want to lease for any reason to be involved in some kind of a hearing. But what has happened is there have only been 3 of those hearings in the last 2 in the last 10 years, and one of those and most of the ones prior to the last 10 years were between operators, where operators would get into a dispute and someone needed to drill an offset. But there have only been 2 hearings under that section in the last 10 years. Okay, let's go on to our subject of conflicts between landowners. And it's important here, I think, especially for the oil and gas companies are the ones that focus on this, but it's important in understanding forest pooling to understand the different categories of landowners. And we just came up with some acronyms which nobody needs to use, but the idea is if a landowner owns both the surface and the oil and gas mineral rights, then they're usually willing to work with an operator for the right price. Although we have seen just in the last 2 years, as opposed to the 6 years before that, we've seen more landowners who say, I don't want a well on my property. I mean, something seems to be happening that's happened with pipelines too. There's more of the NIMBY, not in my backyard type thing. But in most cases, as long as the operators are presenting the right price in royalties and bonus, and also getting the other terms to protect the land, these full landowners are interested in going ahead and leasing, especially if the drilling pad is not on their property. And I think it's important to think about the difference. Now that we have this horizontal drilling, the operator has much more room, much more negotiation room, because they can put one pad on 7, 8, 10 acres and then drill under, if you will, 600 up to 1280. Who knows how many are going to be included? This is, of course, one of the questions that comes up. Another owner that you focus on are the surface-only owners. These landowners own the surface, but they don't own the minerals. And this can be a real problem, obviously, for them, because the mineral owner, at least in Ohio, the owner of the minerals has the right to do whatever is reasonable on the surface, even without ownership of the surface. So typically the surface owners are going to get some kind of approach by the oil and gas company, but be paid a much smaller amount, and they're not going to get any royalty. They hopefully just get some bonus. Now, some landowners, some of this land over in eastern Ohio is in what's considered Appalachia, where it's already had coal mined, and the land isn't worth that much. And in those areas, the surface owners are eager to have a drilling pad on their property because they can get somewhere between $25,000 and $50,000, $5,000 to $10,000 an acre for the drilling pad. The third owner in the picture are the mineral-only owners, and of course, typically they want to lease, because otherwise, what's the value of owning the oil and gas minerals? And so this is not nearly as much a problem as with the surface owners, and even less difficult for the operator, as is the full that we described earlier. Now, there's one other point that I wanted to mention, and that is, did we have it on this slide? No, I go back. On one of the earlier slides, we talked about the Dormant Mineral Act. Ohio's Dormant Mineral Act had not been interpreted until last fall. And because the fall of 2016, and because Ohio has had oil and gas for so long, there are more than people would think severed minerals going back to the 1890s and coming forward. Ohio adopted a Dormant Mineral Act in 1989 and then amended it in 2006, and attorneys and others were guessing as to what the effect of this would be, and most of the guesses went to saying that the 1989 Act would be self-executing. That is, that the old minerals would merge with the surface based on a number of, the basic rule was if there were 20 years of no activity, and there, of course there's a list of 6 or 7 items that constitute activity. But what that led some of the oil and gas companies to do, who were drilling in this shale, which is very prolific, the Utica Point Pleasant. And there's some Marcellus, but mostly it's Utica Point Pleasant in Ohio. The operators went ahead and drilled, if they got leases from the surface owners, which the oil and gas companies believed had also the minerals because they had merged under the 1989 Act. The Supreme Court came out and said that the 1989 Act was not self-executing, so that a lot of these old minerals then were unleased. So this has caused a lot of extra activity, I guess you could say, and it's the cause, again, of where it relates to the forced pooling is that the oil and gas companies are now coming in and using 150928 to try and pick up those severed minerals. I think from here, this is yours, Jack.
Okay, and I want to actually go back to something you talked about with respect to the surface-only owners, and though this doesn't apply to our forced pooling discussion, I just want to point it out. So in Colorado and most of the states in the West, though the mineral estate remains the dominant estate, there's both the accommodation doctrine where you have to, the mineral interest owner, the operator has to accommodate the use of the land of the surface owner. But more importantly, to the point that Dick had made, in almost every jurisdiction in the West, what an operator has to do before they can come in onto the surface is negotiate in good faith for a surface use agreement that will set forth, the conditions under which they can drill, and only if, after good faith negotiations, they can't agree to a surface use agreement, then they can go back to the Oil and Gas Commission, and depending on the jurisdiction, there are ways they can say, hey, we really, really tried, but we couldn't get in. And so like in Colorado, it's a process that we call bonding on. So they will put a bond in with the Oil and Gas Commission that's designed to provide for damages in the event that the operator, doesn't fully reclaim and there are any damages. But the point being, almost always there ends up being these surface-only owners, which is more typical the case in Colorado. Most of the time, the surface and the minerals have been severed. Most of the time, they're going to end up having a surface use agreement in place. So now let's talk about kind of the day-to-day practice, the day-to-day implications of forced pooling from the perspective of the competing interests of the landowner and the operator. In kind of a day-to-day practice, it may be fair to say that small mineral interest owners or owners of small tracts are more likely to be subject to forced pooling efforts. There's also, and Dick has alluded to it, you run into a situation where a broker or an operator is negotiating a lease, and again, in lots of situations, it's not actually the operator, but somebody working for the operator who's going out taking leases, and you run into situations where that broker or that operator will say, here's the lease, take it, be happy with it or not, but take it or we're going to go and force pool you. And I think that there can be some unscrupulous or less than upstanding brokers that use that leverage in ways that is probably beyond what was intended. And we talked earlier about the fact that under the forced pooling statute, there is the requirement that a good faith lease has been proposed. And the problem, of course, is that, just as an example, the rancher out in the Eastern Plains who is being approached by a broker in a pickup truck who wants to sign a lease on the hood of the pickup isn't going to know, or may not know, that that the threat to forced pool has some holes in it as well as some force behind it. So it ends up being an interesting battle of interest between the operator and the landowner. Dick, you want to comment on that?
Yeah, Jack. I from the landowner's perspective, I think the language here in this slide, or said, is used. It's the reality. And typically what we're seeing is that the oil and gas company itself, as you suggested, will have a service company working for them, and the land agent that's working for the service company that is really hired by the oil and gas company will be the one that will talk about, if you don't accept our offer, we're going to force pool you. And then by the time, if the landowner, most often the landowner goes ahead because they've got a smaller tract, or they just don't want to fight. If they do seek knowledgeable counsel that tells them you ought to resist because the offer that you're receiving isn't commensurate with other people in the neighborhood, then we'll end up talking with the oil and gas company, who is the operator or the prospective operator of that unit, and they're more careful because typically they don't want to show up at the hearing and have landowners or their counsel, and landowners can appear before the ODNR group on their own, but typically the oil and gas companies would rather not have that happen. But the bottom line is, as I said earlier, that with the standard order that comes out in forced pooling hearings, more often than not, people do go ahead and accept the lease that they've been offered, even if it's not as high as what some of the other people are. But this is just a major problem for landowners, and the way the statute's written, it's like eminent domain, and they might as well, explaining it, as I said earlier, is very difficult, and you're delivering this bad news, especially if someone has a sizable piece of property. But the fact is that it goes on, and it depends which side of the table you're on as to whether you think it's fair or not.
That brings up an interesting point. For the most part, in Colorado, and I would say in most of the West, North Dakota and Utah and Wyoming, you rarely see real disputes and real fights at the Oil and Gas Commission over forced pooling between an operator and a landowner, in part because the landowner, again, most of them can't go out and hire the geologists and the engineers required to really have a chance of defeating an application for forced pooling. What you'll get sometimes is the more generic, we just don't want it, and it's not fair. So it turns out that the real time you see forced pooling applications really being contested is when there's an operator on both sides.
Right.
And, in which case then it becomes a battle of the experts, but you rarely see it with respect to the landowner, and which as you were talking, I was thinking about the fact that probably is evidence that there's some flaw in the system, because it ought to be perhaps more of a mechanism for a landowner to be able to persuasively contest forced pooling. But I guess the flip side to it is to say that if you're going back to the concepts of Professor Kramer's quote earlier, of preventing waste and conserving resources and protecting correlative rights, a company that comes in and does the application the right way, it's really hard for a mineral interest owner or a landowner to come in and say that the company's wrong and that it shouldn't be forced pooled.
Well, I mean, the law is the law.
Dick, I'm going to go to the last slide, because we've got about 2 minutes or so until we're going to open up for questions. But one concept that we wanted to mention is kind of this: how does forced pooling change, if at all, given new drilling techniques, given shale plays, given some of the horizontal pooling or horizontal drilling that's being done now, with laterals that are so long, 2 and 3 mile laterals. And what we see in the West, and Dick, I'm interested to hear your perspective from your area. But what we're seeing now is, where spacing units, just a few years ago, a 640-acre spacing unit was an enormous spacing unit, and now you got 1280s and you got 2560s in places in North Dakota. So now you're getting these huge units, and then you have the concept of, okay, if we're going to force pool people, and we're going to force pool them into, let's say, a 1,280-acre spacing unit, and then one well essentially can hold the entire unit. Is that what was intended, really, when we first started with forced pooling? In almost any jurisdiction, it was when you had vertical wells, and then you tried to adapt the horizontal drilling perspective to it. So is that what was intended? And then do you really get to a point where, okay, that's fundamentally unfair and maybe is contrary to the principles underlying forced pooling in the first place? But
yeah, I think
definitely interested in your perspective.
Yeah, I think it's a really good question, and we haven't faced that here, because the 1509.28, the larger tract forced unitization, has only been used for 5 or 6 years now. But I think it is a real question, and I'm hopeful that from a landowner's perspective, that what the state regulatory agencies will come with is that if someone wants to drill a well on 1280, that would actually require 3 or 4 wells, and that the first well will hold, say, a quarter of it for X number of years. And if you then drill the second well within a certain period, in other words, the permit that's given for the unit has some staging in it, so that one well doesn't hold the entire unit forever. But again, then you get into what the terms of the leases are, and at this point, we just don't know what the state will do with that issue. But I think it's a major issue.
And I will say that states out here have been dealing with issues surrounding, or the fact that horizontal drilling, now being more the norm than vertical drilling, is butting up against spacing and density and other rules and regulations that were designed for vertical wells, and they may not always apply as well. And so, in Colorado now, you've got a framework which we don't even want to get into, but where you can have overlapping spacing units because of the vertical and horizontal natures of the units, and to say that gets confusing, or at least confusing to me, would be an understatement. And other states are starting to deal with that and recognizing that their regime may not, the regulatory regime may not be keeping up with the times quite yet.
Right.
But with that, we want to make sure that we give adequate time for questions. And I do want to put the pitch in that if for some reason a question doesn't get answered today or doesn't come to you, or if an issue comes up, after this presentation, I speak for Dick in saying feel free to contact either one of us at any time, and we'd be more than happy to answer questions or help however we can. But now I'll turn it over to the moderator.
All right. Thank you so much, Dick and Jack, for your insights today. Before we go on to that Q&A, I'd like to make a brief announcement. New York State requires that you record and report the following code in order to obtain CLE credit for the live or the recorded version of this CLE webinar. If you will be requesting CLE credit for this seminar, please write this code down. The code is TLDYGG. So that's T is in Tango, L is in Lima, D is in Delta, Y is in Yankee, G is in Golf, and G is in Golf. So again, that's TLDYGG. Okay, now on to our live question and answer session. Listeners, you can ask our speakers any questions relevant to today's topic. You may email your questions to envlaw@stratfordpub.com. You can also submit your question by typing into the Q&A box at the bottom left corner of the screen and clicking send. Or you may ask by telephone. Excuse me. To do so by telephone, press star 1 on your touch-tone phone. And if for any reason you decide not to ask your question, press star 1 to remove yourself. After you press star 1, when it is your turn, your name and city for the person registered to your location will be announced. And if you'd like to identify yourself further, please do so at that time. Again, if you're asking by telephone, please make sure that the desktop sound of your computer has been turned off. Okay, we do have a question typed in. Please discuss any distinction in forced pooling application between unleased parcels and parcels that are leased with non-conforming lease terms, such as smaller unit limits. Does the public policy favoring pooling trump negotiated contracts entered for consideration, such as an existing lease?
This is Dick. What we've seen in Ohio is that, yes, it does. Although we have tried to make objections, and so far we haven't had a case where that's been appealed, so I'm not sure what will ultimately happen with it. What do you see, Jack? Say you've got a lease that says that there'll be no, going back to one of your early slides, and we were talking about the size of limits on units. So say you've got a lease that says pooling can be up to 640 acres, and there's no wiggle room, although most oil and gas leases do have wiggle room, and the operator wants a 1280 unit. Will Colorado, or if you know as to other states, will they just ignore that, or what approach will they take?
I'm having a hard time remembering, a specific instance. But what I can suggest is that most of the time, I believe that the interest of protecting correlative rights or of efficiently draining the acreage is going to be more important than the private contract. And so I think it would be difficult to argue that the private contract keeps the trumps, and I think I'm using the word trump in a different context or in the reverse context it's in question, but you can't contract around the public policy in favor of efficiently draining the acreage.
Yeah, I think that what happened in Ohio with 1509.27 is a good example of what would continue to happen in Ohio and may happen in other states. In that, in the hearing where we represented, this was under 2.7, the small tract, where we represented one operator who needed 2 acres from an adjoining operator to get into a sufficient size unit. And at that time, the wording in the statute was that the application is proper in form and that mandatory pooling is necessary to protect correlative rights, to provide effective development, or conservation of oil and gas. Within a year after we won that hearing where we got this 2 acres for the operator, the legislature changed the wording and made it so that it's now and. So anyone trying to utilize this would need to comply with all 3 of those, which now requires more geological and petroleum engineering testimony, which makes it more costly to do that, which is again one reason why there have been so few hearings. But I think that I agree, as I said earlier, with what you said. I think that the basic policy that the state is interested in the development of oil and gas minerals will prevail, and that the contract language will be set aside or overlooked or ignored or whatever word you want to use.
Yeah, I think in practical terms, too, I could see where landowners would perhaps want that restriction. Again, thinking out here, I'm not sure that in current leases, leases going forward, an operator or the lessee would ever agree to a restriction like that to begin with, and so I'm not sure in practical terms how much it's going to come up. And I think we have another question.
Yes, we do. Can surface owner who is pooled receive compensation for gathering pipelines located on the property as a result of spoliation of mineral estate?
I'll take that first. Again, in most jurisdictions in the West, the operator is going to have to go to the surface owner and get a surface use agreement. Frequently, that involves some sort of compensation for property damage, for roads, for pipelines, and so it's not uncommon to see something that will say, we will pay the surface owner X amount for each well pad. We will pay X amount for each, foot, meter, yard, whatever measurement of pipelines, and for each, mile of road used pursuant to this agreement. So, and all of that is to one extent or another subject to negotiation. And so the surface owner sometimes, frankly, sometimes the surface owner has some pretty darn good leverage and can get some decent compensation out of it. At least that's been my experience. Dick, do you have something different than that?
No, I agree with what you said, Jack. I mean, it's a question. Obviously, if it's just a mineral owner, I don't think that they are going to be able to get the compensation for a surface, but that would then again go to what's the reasonable use. I mean, typically somebody that just owns the minerals, they're giving the right to drill under their land. Now, if you get into what is reasonable use of the surface, and that would be the question for someone who's just the mineral owner.
Right.
And is a gathering line? I think there's also a necessary test in there, reasonable and necessary. I don't have the case in mind in Ohio, but you have to show that you'd need to show that they couldn't put the line somewhere else, and that it was both reasonable and necessary for a mineral owner to be compensated for a gathering line.
Okay. Anything else?
We have no further questions, and we are just about at time. But we would like to thank everyone and hope that you have enjoyed our national webinar, Forced Pooling in Oil and Gas, Navigating State Laws, Addressing Conflicting Rights of Landowners, and Use in Negotiations. If your question was not answered or you do have one later on, you may email it directly to our presenters. Their email addresses are included in the presentation materials. If you are seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to this form will be included in the thank you email that you will receive immediately following the program. As long as you have registered and paid for this program by 5 p.m. today, you will receive your certificate of attendance within 24 hours. If you have any questions about continuing education credit for this webinar, please call our Continuing Education Department at 404-881-1141, extension 35. Today's participants can order a recorded version of this event at a special attendee price. Please call our customer service at 800-926-7926, extension 10, or visit Stratford's website at stratfordpub.com. Please be sure to check Stratford's website for information on future Stratford CLE programs, including a webinar on midstream, executing contracts in bankruptcy, navigating court treatment of transportation, gathering and processing agreements, negotiating midstream agreements. That will be on Tuesday, August 8th, 2017, starting at 1 p.m. Eastern Time, lasting for 90 minutes. Stratford would like to thank you for your attendance. To end this call, simply hang up your telephone. Thank you and goodbye.